Hello everyone and welcome to the first of this 10-part series focusing on the law of contract in England and Wales. The aim of this lecture series is to introduce you to some of the key concepts that underpin the law of contract and to give you some guidance on how to study that as well. I find, having studied contract law for many years and having practiced it in industry, that it can be quite difficult simply due to the volume of information available. So the aim of this mini lecture series is to break it down into its constituent parts to enable you to learn it more efficiently. So let's get stuck in.
So in terms of our plan of attack, we're going to start by looking at why exactly do we need some form of contract law? Why do we need regulation when it comes to the dealings between parties, both business to business and business to consumer? And as part and parcel of that, we're going to look at the origins of contract law and the introduction of that laissez-faire economic system at the dawn of the Industrial Revolution. And then we're going to touch on one very important facet of contract law, and that is what we call the objective approach as to interpreting contracts. And that is what the courts will do, and that's how the courts will read contractual agreements between two parties. The final thing that we're going to cover then is the structure that we're going to use throughout this 10-part lecture series to teach you contract law. As I said in the introduction, it can be quite a voluminous subject and it can be quite easy to get lost. So hopefully by following a set structure, you will be able to avoid that, and that's what I'll introduce you to at the end. So the first question that we're going to ask ourselves is, why do we need contract law in the first place? Well, I suppose the natural answer to that is to make promises binding. Where would we be if Party A could just renege upon their promises to Party B? What if a building contractor suddenly decided that they were not going to turn up to construct the building, to construct the hospital? So there's a valid reason why we would want to have some sort of regulation to enforce those promises and to give the innocent party some sort of recourse if those promises are broken. But in actual fact, there is only one type of promise that will be enforced under English law, and that is a promise which is supported by consideration. Consideration is something we're going to consider in a lot more detail as we go throughout this lecture series, but think of it for now as something of value being exchanged. So to link that back, a promise will only be enforceable if it is supported by consideration or something of value. There's a slight exception to that, however, and that's where promises are reduced into a document known as a deed. They don't require formal consideration or something of value to be given in exchange, but that is a very narrow exception to the rule and not something that we cover in too much detail as part of this series. The next bullet point that we have there is the nature of our society itself. We live in a market capitalist society, or some may say that economic philosophy of this country is tilted towards a market capitalist structure. In other words, we buy and sell every day. It would be practically impossible to go about our day-to-day dealings if promises were not enforceable as part of that. Think of trying to run a society where one party just turns around and doesn't fulfill their side of the deal. It just wouldn't work in the society that we live in. You know, that the example is, who would book a package holiday if you were not guaranteed that the operator would fly you home at the end of it, to give an example. One thing to remember, however, is under English law, when it comes to enforcing contracts, it would be a fairly rare thing for the courts to order and to mandate performance of a contractual obligation. What they do instead is they tend to remedy deficient performance, or they try to remedy non-performance by compensating the other party in damages. In other words, trying to compensate them in money to put them into the position they would have been but for the breach occurring. So the next thing that we're going to consider is the origins of contract law within England and Wales. I think this is an important thing just to have a broad appreciation of, so that you understand why the rules are set up in the way that they are. The majority of the rules then that we're going to be considering, they are quite old and they do date back towards the early 19th century. There's several cases that we'll look at that are still good law today, such as Hadley and Baxendale, which is the seminal case which deals with the remoteness of damages. Myself, as a construction lawyer, I would still refer to that case on a regular basis when trying to determine what sort of damages are recoverable and which aren't. We'll look at the case of Hyde and Wrench to do with counter-offers, and we'll look at the case of Smith and Hughes from 1871 on the next slide to do with that objective approach to contracting. And there's plenty more from back in the 1800s, because that very much is where contract law started to develop rapidly within the law of England and Wales. So it's important to understand why all of this change started to occur at the beginning of the 19th century. Because prior to that, a number of areas of life were highly regulated in a very different way than what we would be experienced and familiar with today. The likes of a baker or a miller were only able to charge a certain amount for their products because those products were seen as a basic staple of life, a very left-wing way of looking at things. What started to emerge, though, at the start of the 19th century was a slightly different way of looking at things, and there was a political shift towards what was known as the laissez-faire system of economics. And that's effectively an economic system where everybody is let loose to do what they want. Individuals are free and absent from any sort of economic, interventionism, any regulation that governs what they do, and they were free effectively to charge whatever they want depending on the market price. And as a result of that, the number of transactions and the business of business itself started to increase, and with that came the requirement for some sort of regulation to govern that. And that very much was the genesis or the origin and the requirement for contract law as a branch of law in its own right, because prior to that, contract law didn't exist as its own separate entity of rules as we know it and study it today. So, having talked about why we need contract law as its own distinct area of law to be studied, and the origins of contract law dating back to the early 19th century, the final thing that we're going to cover in a little bit of detail is what we call the objective approach to contracting. Again, myself as a practicing construction lawyer, and this is something that pops up all the time, because believe it or not, even when you're dealing in construction, something where you would think quite a lot of contracts would be, robustly put together, that's very often not the case. And there's always a question of what exactly did the parties intend to do by that agreement? What did they intend that agreement to look like? And what did they intend their obligations to be? So before we get into that, just as a preliminary point that some people who are very new to contract law must understand, is that not all contracts have to be in writing. It is perfectly fine to have an oral contract. You go into Starbucks and you purchase a tall pumpkin spice latte or whatever it may be. There's an oral contract has arisen there. There's nothing that you sign or agree with Starbucks as to the quality of that product that you're buying, but it would be implied into that oral contract that you have. And that's when this objective approach to interpretation is really important, is what was the intention of the parties, using that transaction as an example. What was my intention by going in there and purchasing that coffee? What did I expect that coffee to taste like and look like and ultimately do for me? Bad example, I know. So what the courts will do when asking themselves that question as to what did the parties mean by their agreement, or what did they intend to mean, they use what's known as the objective approach. And quite simply, the courts will not put themselves into the shoes of either of the parties to the contract. They don't look at their subjective state of mind. They don't look at their subjective intentions. They look at their objective intentions. I'll say that again. They look at their objective intentions. And what that means in reality is that the courts will put themselves into the shoes of the reasonable man, observing the parties entering into that agreement to try and understand what, objectively speaking, they intended the agreement to be. And the first case then that we're going to consider as part of this lecture series is Smith and Hughes from all the way back in 1871. Again, the facts of the case are not particularly important. It was to do with a contract for the sale of oats for a racehorse. Again, that's what racehorses eat. But what we want to take away from this course or this case is the comments that were made by Justice Blackburn, Justice Colin Blackburn in that particular case. This is a fairly famous quotation. Again, as a practicing construction lawyer, this is one that I have used in the past because it really does hit the nail on the head as to what the objective approach actually means. With the benefit of having YouTube, what I would invite you to do at this point is to pause and to read that quotation quite closely. Really do read it slowly and understand what exactly Blackburn was trying to articulate here. And I think once you've done that, really get it into your head, and it will all start to make sense. So assuming that you have paused it and that you now understand it, I'm now about to read it out. And he said, "If, whatever a man's real intention may be, he so conducts himself that a reasonable man would believe he was assenting to the terms proposed by the other party, and that other party, upon the belief, enters into the contract with him, the man thus conducting himself will be equally bound as if he had intended to agree to the other party's terms." So what that means in reality, if by my outward actions the reasonable person would think I meant X, then that is the term of the contract. It does not matter if in my mind subjectively I was thinking it was Y. By my outward approach and by my outward actions it looks like X, then that is what the courts will interpret into the agreement, and will interpret the agreement as meaning. I appreciate that the comments from Justice Blackburn and his vernacular are slightly outdated this day and age. So what I would invite you to do is go away and look at the more recent UK Supreme Court decision in RTS Flexible Systems. It's a case from 2010. Paragraph 45 of that decision is very similar to that, and it restates the law in a very similar way, but it updates the terminology to be slightly more modern and talks about that subjective state of mind that we talked about previously. So go away and have a look at that Supreme Court case of RTS Flexible Systems of 2010. So having covered off those preliminary topics, which are important to give you a good grounding before we start in earnest into our studies of contract law, we're now about to look at the structure that we're going to follow for the remainder of this 10-part lecture series. So this is the structure that we're going to follow throughout the remainder of this series. Again, looks very bleak at the moment, but as I click through it, all of the various topics which all go together to form contract law will all start to slot in, and to show you how they fit together is very much the intention here. So I've broken down this entire subject into the 4 quadrants within this diagram to explain how it all operates and works together. So the first thing that we're going to consider, and we do this in episode 2 and episode 3, if you want to call it that, is offer and acceptance. These two things together, the offer and the acceptance, are what form the contract and is what's known as the agreement. So if I go to offer someone to buy my mobile phone, I will make them an offer, and then they can accept that and buy the phone off me. But that's only part of the equation. There's a couple of other things you need in order for that contract to form. The first of those is an intention to create legal relations. It's all well and good having the offer and the acceptance, but if there's no intention to form a contract there, then there will be no legally binding agreement. And that would quite often be the case in a domestic arrangement. Say for instance between a husband and a wife or flatmates, where they make some sort of agreement between themselves, but there is never any intention there for that agreement to be legally enforceable, where the husband could take the wife to court or vice versa, or the flatmates could sue each other if one doesn't do the dishes on the Monday evening and every other Monday. So if there's no intention there, there can be no contract. The final thing that you need then is to form the contract is something we've already discussed at the beginning of this video, and that is this legal concept of consideration. And as we said previously, consideration is effectively an exchange of something of value. It doesn't have to be money, it just has to be something in the eyes of the law that has a value associated with it. Consideration must be sufficient, but it need not be adequate. It's one of the rules that we will look at in a bit of detail later on in episode 4, I believe. So those three things together, the agreement, the intention to create legal relations, and consideration, are the three pillars that you need to form a contract. And if you're watching this video in preparation for an exam as part of an LLB, for example, a contract formation question is almost guaranteed to come up. So some sort of question where the parties are offering an object for sale, and it seems on the facts that it's been sold to maybe 2 or more of those parties, you have to go through the facts and understand where the contracts form. And you will do that by applying the principles that you will learn in those series of lectures. So that's very much one topic in its own right, and that is contract formation. The next topic that we're going to look at is the contents of the contract itself. And we're going to look at the various terms that will be within a contractual agreement and how those terms become terms, how pre-contractual statements said before the contract is entered into manifest themselves into express terms of the contract and when they won't. And we'll look at all of the rules that surround that. And we'll also look at things that haven't been said between the parties, and those are the implied terms. And there's various different ways and mechanisms by which terms can be implied into a contract. So if you're buying, standard goods off the shelf, there may be certain terms as to the quality of those goods or the fitness for purpose. Or if you're supplied a sample of a type of goods, the expectation that all of the other goods will conform with that sample. There's various different implied terms under the likes of the Sale of Goods Act that would cover those sort of things. And again, for me in construction, there's implied terms within construction contracts that I would deal with under the Housing Grants Construction and Regeneration Act. But that's a bit more specific for construction, and we'll park that for now. And then the final thing that we'll look at is one very specific type of express term, and that is an exclusion clause, some sort of provision that tries to operate to exclude liability, or alternatively to limit liability, perhaps to a set amount or to a certain type of loss. Those can be quite onerous provisions to sign up to. And for that reason, they're usually governed by some sort of statutory control. And we're going to look at the terms that will be implied by UCTA, the Unfair Contract Terms Act, and the provisions of that act which seek to control the use of exclusion clauses. The likes of, making it illegal effectively or unlawful to exclude liability for death or personal injury. And you can't do that by law due to UCTA because it is a statutory control on our right and our freedom of contract. So as we say, all of those things together are another topic in their own right, and that is the contract contents, or the contents of a contract. Again, you're moving down from the contract formation, you're already in contract at that point, and now you're talking about the contents of the contract itself. The next thing that we're going to look at then sort of evolves on from that. So we're in the contract at this point and we understand what the contents look like, and we're now going to look at how do we enforce those contents. How do we enforce the rights and obligations of the parties to the contract? And what happens if they are not followed? What happens if there is a breach of contract of some sort of strict obligation? What are the remedies available for that? Be it damages, or alternatively some of the equitable remedies that are available as well, injunctive relief, specific performance, and we will all cover as part of our enforcing the contract lecture. And then the final thing within our structure that we're going to look at is the discharge of a contract. And quite simply, that is the bringing the contract to an end and that contract ceasing to exist. There's a number of ways in which that can happen by performance. So linking back to our Starbucks analogy, if I drink the tall pumpkin spice latte, throw it in the bin, that's the contract over, it has been performed. Or alternatively, it could be discharged by repudiation. If the coffee is out of date or it's inedible, there's a repudiatory breach there because it goes to the root of the contract on the part of Starbucks, not that it ever would. And that would bring the contract to an end as well, entitling me both to terminate the contract and to seek damages for that, which in that scenario would probably be a refund or another coffee. So that's the contents of what we're really going to be focusing on as part of this series. But there's one final topic that exists slightly outside of the contract itself, and that is the concept of misrepresentation. So I said previously that we're going to look at how to draw the distinction between pre-contractual statements which form part of the contract and those that don't. But we're also going to look at the scenario in which some of those pre-contractual statements were misleading. They were false statements of fact or law, which ultimately induced the contract, and we'll look at the remedies available for that. Because it's unfair for a party to enter into a contract on a false premise. Again, for myself working in construction, that's something I would see quite often, where representations are made about the state of the ground conditions, for example, and then one party turns up onto the construction site, puts a digger bucket in the ground, and it's going to cost a lot more money to construct the foundations than they had allowed for because they were misrepresented in the state of affairs on the site. It is slightly outside of the contract agreement itself. It's something that doesn't arise as part of the agreement. It's something that induced the contract itself, which is why I've shown it outside of our little four corners of the page there. But it is a useful topic, and it is something that people would study as part of contract law as well. And the final thing that I just want to introduce you to is the way that I'm going to be teaching this lecture series, and the way I'm going to be teaching the various topics within it. And that is by breaking each of those topics down that you saw on the previous slide into a couple of high-level topics and subtopics. I think by really breaking it down into that high level and always keeping the perspective, it makes studying contract law that little bit easier, because it's very easy to go down the rabbit hole and to lose yourself within the volume of cases and whatnot. What I've shown you here then is an example of that with the topic that we're looking at in the next video, and that is what amounts to a valid offer within contract law. So to explain that concept of offer, I've broken it simply down into the definition. So by contrasting the two very similar cases of Storer and Manchester City Council and Gibson and Manchester City Council, two cases against the same defendant of very similar facts that had two very different outcomes that exemplify perfectly what it is and what amounts to a valid offer. We'll then look at invitations to treat. I'll talk you through the recognised examples, and then we'll look at terminating an offer. And those three things are the key things that you must know about the concept of an offer. You can break it down into much more detail than that, but it ultimately boils down to those three things. And where that becomes useful then is when you're revising this topic, and hopefully this little example starts to make some sense. Because what I hope you will be able to do is to take away all of my summary slides within each of the videos, put them together like a jigsaw, and what you will ultimately be left with is a mind map of this entire subject that you can then go away and add the further layers of detail as and when required to study for your exams or to help you with your coursework. So for example, in looking at a termination of an offer there's 7 different ways in which you can terminate an offer. So the point is, you can take this diagram and you can draw 7 little arrows and describe the case that's relevant to each of those means of termination and give a little explanation of it. And again, it breaks it down and keeps it nice and neat. Some of those means of termination have an exception, so you draw a further line out from that into the 4th tier of detail, and again breaking down what the key cases are, breaking down what the principles are, all with a view of helping you to understand it. And then there'll be some of these topics that interrelate, and what you're ultimately left with is a nice spider diagram to help you understand what contract law is all about. So I hope this video was useful, and stay tuned for the next one.